Thanks everyone for joining us. Welcome to Financial Poise webinar, Key Provisions in M&A Agreements. And this webinar is episode 2 of the 5-part private company M&A Bootcamp 2025. Today we are produced both by Financial Poise and the National Law Review. Slide 6 of the PowerPoint summarizes this episode, and slides 7 and 8 summarize the whole series. Speaking of the slides, we're not going to step through the PowerPoint in any kind of order. You're not going to have to listen to us regurgitate any of the slides. This webinar, like all Financial Poise webinars, is an informal conversation on the subject matter with an interesting panel. Keep the PowerPoint handy if you wish. We may indicate which slides we're touching upon as we chat. If you're old school like some of us are, you could print it out and take notes on it if you wish. We're joined today, and our panelists are Michael Weiss. Michael is a principal of Weiss Bernie LLC, which is a boutique corporate and real estate transactional law firm in the Chicago metropolitan area. As a transactional legal veteran, Michael represents privately and publicly held entities in business and commercial transactions and handles the negotiation and closing of complex corporate and commercial real estate transactions, both domestically and internationally. In addition to being a Bears fan, he is also a certified public accountant, and his experience includes all aspects of mergers and acquisitions, securities, and corporate governance. The panel is rounded out today with Jacqueline Brooks. Jackie is a corporate partner in the Baltimore office of Duane Morris LLP. Duane Morris LLP is a national full-service law firm. Jackie concentrates her practice in general business and commercial law. She counsels clients in mergers and acquisitions, commercial finance, private placements, and corporate governance matters. Jackie has experience representing public companies, privately owned and family-owned companies, nonprofits, and emerging companies. I'm your moderator, Robert London. I am a partner at Jaspin, Slessner & Narendran, which is a full-service law firm, a stone's throw outside of the Manhattan, New York area. I'm a transactional attorney as well. I do M&A, executive compensation, asset-based lending, startups, basically whatever tough to negotiate and fun to draft and vice versa is what I do. I'm sure you're thrilled and want to learn more about us, and we could talk the entire hour about us, but we appreciate you not spending your time and money to hear our infomercials. If you're interested in us, you can flip to the back of the PowerPoint to read our bios. This webinar is a production of Financial Poise, and as I said, co-produced by the National Law Review. If you want to learn more about Financial Poise, you can see slide 37 of the PowerPoint. I believe one of the slides in the deck also talks about the National Law Review, our co-producer. If you're attending the live premiere of the webinar, you can submit questions using your web portal. And if you're watching this or listening to this on demand after you so ingest all of the information that you're going to get and have any questions, you can send an email to info@financialpoise.com. Remember, the PowerPoint conversation we're about to have are meant for general educational purposes and do not replace the need to consult with an attorney, accountant, or other appropriate professional. In other words, if you're silly enough to take significant action based on something you hear today, don't come paging through the PowerPoint looking for our bios to come knocking on our door for your silliness. Seek an appropriate advisor. All right, we're talking M&A today, and we're talking key provisions of M&A agreements, and we're going to get this party started with Jackie. Jackie, you're representing a buyer which is feeling a little uneasy about a transaction and wants as many open-ended closing outs as possible, including a satisfaction with buyer's due diligence and its sole discretion closing condition. The seller is pushing back. How do you advise your client? What's market here?
So first, I would tell the client that I am a Ravens fan. Make sure we get that on the record. But generally, in today's market, unless the buyer has a tremendous amount of leverage when it comes to negotiations, many buyers will not be able to get this due diligence out, if you will. Even if you were to change it from being the buyer's sole discretion to being a reasonable discretion, many sellers will not agree to it. But the good news for the buyer is that a lot of this is within the buyer's ability to have the diligence done before they actually enter into the purchase agreement or sign the purchase agreement if it's sign with the closing to happen later. Also, a lot of times what buyers do for this, if time is of the essence and they need to sort of get things done fairly quickly, they have the ability to do red flag diligence, where you would sort of look at the things that are very important to the buyer or may make the buyer walk away from the deal, to determine, quickly whether or not they want to move forward without, as much legal cost and spend and time spent in doing diligence. Also, currently there are a lot of diligence programs that have AI built into it, which do allow some diligence to be done quicker. But the most important thing on that is to make sure it's a closed system so that you're not violating that confidentiality agreement that you entered into, and you're not exposing the seller's information to the public.
All right, I'm going to go off the reservation here because you mentioned something very interesting, which is almost ripe for an entire webinar or a sixth chapter of this series. And yes, sports fans, we are going to go back and go through some key provisions, but let's talk generalities here. How is AI entered into documentation and diligence these days, from your point of view? It hasn't quite hit my practice yet because I pretty much, my playground is the small to mid cap deal. Every now and then, when you have a large financial buyer, maybe it pops up. Has then, what are you, what are my panelists seeing in that regard? And does it let's focus it just on documentation because that's today's documentation. But I'll make a note to the financial voice people, which is would love to figure out and learn and craft a webinar exactly on AI in transactional work. What are you people saying?
I'll jump in first on this. You're right, Robert. It is new. I think in my observation, the jury is still out. No pun intended on the legal side. I AI is really just making faster the process of going through documents, abstracting contracts, abstracting leases, abstracting agreements, summarizing information. Um, but ultimately, at least in my practice, where we're at, and thankfully, we're still needed as counsel to evaluate what that AI is doing. It's not really, in my world, making the decisions are strong, but it's getting there, and it's certainly moving the process along, especially with regard to condensing financial information and reporting on financial information, sort of backroom activities. It's real quick. But then uh, the human side still has to evaluate it and decide what it all means in the context of a deal. But you are right on to point that out because, 5 years from now, 10 years from now, I think it's only going to be more advanced, and we will see. I just don't think it's there yet.
Yeah, I mean, I've seen it now in deals where we're using it as Michael mentioned. So in contract due diligence, in understanding sort of change of control provisions, assignment provisions, and really now you can sort of use it to shape many of the different things you're looking at, whether it's indemnification or minimum purchase types of contracts, depending on what the diligence is on. I've also seen it be used when you're dealing with a company that maybe has been around for a while and you have various employment agreements or other sort of standard agreements to see how they've changed over time, and make that a little bit easier to sort of digest without having to actually sit, as we used to when I first started, and go sort of page for page. But Michael is correct that we still need the attorneys to review them. We still need counsel and accountants, et cetera, to assist in digesting it. And on the company side, some of them have been using it in connection with sort of project management to help their teams deal with the diligence requests. But again, the biggest issue, I think, is ensuring that you're using a closed system that doesn't allow access. We've had there have been cases where people have placed confidential information from diligence and, chat GPT and other things on free systems, and then the information's out there. So.
All right.
Just a couple comments on due diligence. I agree with Jackie that very often a seller will not allow a contingency based on the buyer's discretion. That being said, although there may not be an express condition of due diligence, my experience has been there really always is due diligence going on. In other words, meaning a buyer will not typically sign a purchase agreement or will delay signing the purchase agreement until this question is answered, that question is, especially material issues or substantive issues. So there may not be an express condition, but either a buyer will have that condition in an agreement or will delay signing an agreement or delay something else until it's pretty well satisfied with where the process is and if they want to move forward and so forth. So I find it, as we'll talk about in this and further, there's always parallel paths going on. There's the lawyers are negotiating the purchase agreement and financial due diligence, operational due diligence, and so forth is going on, and it becomes a little bit of a mishmash. And every deal is a little bit different as to when it all sort of comes together. So I agree that very often it's not an express condition, but it's going on in the background.
All right. I'm going to stick with you, Michael. Can you briefly describe purchase price terms, and let's address whether a closing condition in favor of the buyer being able to obtain financing is again market, and when and how does this topic come into the deal transaction process?
I'm going to take the second part of the question first, regarding financing contingencies when it comes in. Having been at this for 37 years, it seems to me in the old days, I hate to always say the old days, but there were, financing contingencies all the time. Things were slower. Private equity was not as ubiquitous as it is now. And then there's sort of been a gradual change. The last 15 or so years, there's a lot of capital in the marketplace. There's all sorts of funds, and investment in private companies has become faster, quicker, speedier. So there aren't as many financing contingencies, at least in my world, in my practice, as there used to be. Sellers, for the simple reason that sellers don't have to accept that and don't have to put up with it. Generally, if they can sell a business with as few as contingencies as possible, that's great. If I'm a buyer, I like a company, I want to get the company, my offer's good, and I need a financing contingency, I want to talk about that right off the bat. Because as a seller, I am, cash is king. I am weighing speed of closing, ability of a buyer to consummate a deal. It doesn't matter if a buyer is necessarily offering the highest price. Is that buyer going to close? So there are financing contingencies out there, but not to the degree as I saw my first 20 years of practice, and I'm in year 37 now. Purchase price terms, cash is king, as mentioned. If I'm a seller, if I'm getting my price, I want cash. Or sometimes if I really, from the seller standpoint, I really like the buyer's company, I believe in what they're doing, and they're offering me some what's called rollover equity, a piece of the pie going forward. Sometimes I'm interested in taking some of my purchase price consideration in equity. Um, Sometimes there's, in addition to cash, seller notes. If I like the buyer, I like the deal, just can't pay it all right away. Um, Sort of like a financing contingency. Maybe I'm taking some paper. There's also, an earnout, meaning, and we're going to talk more later today and in the future about digging deeper into all of these concepts. It's a good deal. It's the best deal I can get. But maybe I have to take a certain percentage in earnout, meaning I'm not going to get all my money at seller unless certain metrics are met, certain milestones are met down the road. And there could be various reasons why that has to be acceptable. So purchase price is cash, earnouts, rollover equity, seller notes, and all sorts of combinations of the foregoing.
When we talked about the financing out, it just going to go back to something that Jackie said, which is it also depends on structure. Most of my deals are concurrent sign and close, but sometimes you have the oddball where there's third-party consents or a governmental consent, and there's a lot of time between signing and closing. And there kind of matters. And if it matters there, if you're the seller side, then you're probably asking for some sort of non-refundable deposit, because it should be your loss and your lost opportunity if the deal doesn't close because the buyer signed an agreement and they couldn't get their financing. I mean, that's the way I've seen it handled. Also from the sell side, even in concurrent sign and close, you say, I'm giving you exclusivity under our letter of intent. You have 45, 60 days to get your ducks in a row. Tell me about what your, financing is going to be. Maybe then and there you're asking for some sort of deposit as well. I think the last topic we'll kind of talk about for when we have concurrent sign and close, and I'll use subsequent close to sign are material adverse change outs, MAC outs, and we're only going to deal. I'm going to tap Jackie for that. We'll only deal with that a little bit about what a MAC out is, and we'll use this as a way to jump in as to, given that we're dealing with key provisions, what's a material adverse change definition? What is it? What's common for it? Are there any exceptions? I think that might be more useful to our listeners and viewers than discussing a MAC out provision.
No, definitely. And sort of to tack on to the end of what you were saying, Robert, a lot of times when you do, even if you do allow for that, financing out to be, or you're trying to make sure that the buyer actually has the money, the seller may sometimes ask the buyer to provide either commitment letters, like changes, copies of commitment letters or something from their existing lender to confirm that they have the funds if they're going to need financing to close the transaction. But a MAC out. So MAC stands for material adverse change. For those that may not know the sort of vernacular. And essentially what this means is that the buyer is looking for there to be a closing condition that between the signing of the agreement and the closing of the transaction, that there is no material adverse change in the business. Now, that can mean a lot of things. And so this is a definition that can be very heavily negotiated by the parties in deciding sort of what an actual material adverse change is that's sufficient for the buyer to be able to terminate the agreement. And so this will show up both in the closing conditions and then typically in the termination provisions, where it gives the buyer a unilateral ability to terminate the agreement and walk away if there is such a material adverse change prior to closing of the transaction. So that's a MAC out.
I was just going to add, in my experience, a lot of negotiation in MAC clauses, and probably more than any other section of the agreement. And there's always a little bit of tension there. in my experience, because you have a from the buyer side, if the deal changes because conditions have changed, they don't want it, or the business, or pricing has changed. And from the sell side, the argument is nothing stays fluid. Contracts, customers come, customers leave, suppliers come, suppliers leave. So always a lot of time negotiating that, and every industry is a little bit different. So I have spent many of hours negotiating the nuts and bolts of MAC laws, as you guys have also.
So let's talk a little bit about the words, like changes to prospects, in or out, negotiated, what's market, what's not. Yay or nay?
I'd say nay to the prospects. Future looking, no. Current condition, yes.
Okay.
So business operations, if there's material, depending on sort of what this is a business that has a particular large concentration of customers, of a particular customer, and that customer leaves, then that can be something that is negotiated. The financial condition of the company, like whatever the cash flow has historically been, does that change? And many other things. Now, the one thing I will note, despite how heavily negotiated this provision is, courts have yet to really find MAC out that was where a buyer was able to actually exercise it and say that it occurred.
Yeah, a couple things to weigh in on. Yeah, how do you define material? I mean, it's whatever a court says it is. So I find that most negotiations that I'm involved with try to put number parameters around, um, because everyone can test numbers. If something's down 5%, 10%, or 2%. And then after numbers, you get into time frames, and you could understand here as the listener, all people do is keep thinking of more issues and exceptions to issues, and it goes on. But the if it's well defined and clearly defined, and there's parameters, can understand. But if people are just relying on words like material and so forth, very messy. Could be very messy, I should say.
Well, I've done deals for both sides where the exceptions to what is a material adverse change are on the piece of paper twice as long as the definition itself, 3 times, 4 times even. Michael, putting on your seller's hat, if there's going to be a material adverse change definition or even a MAC out, let's go with the more market common exceptions as to what kind of downturns could the business suffer that shouldn't result in the buyer getting, out of the deal or having a claim for, damages if by way of indemnity.
And I'm going to answer this in general terms. And Jackie really was right on point. If we're doing a deal, and something is current, and there's in any business there's ups and downs, and there's things happen. So where does it get out of the range of norm? The time is spent, in my experience, negotiating these. So when I'm on the seller side, we all have language. I'm really trying to limit that to items really out of the box. Force majeure. Well, sometimes not even force majeure, or just you lose a third of your business where it fundamentally changes the deal. So I'm carving out. Losing customers can happen all the time as companies are gaining customers. So I'm trying to limit this to something that's just out of ordinary. I'm studying the last 5 years or 10 years when I'm talking to the seller, we're about to, has this happened? Could this happen? I've always thought the funny thing when you're representing sellers, and I think you guys will agree about MAC clauses, is if things get a lot better, like, I've had some sellers say, well, wait, okay, these are buyer outs, but do I get any additional consideration if things are really great over the last, over the 4 months before closing? Like our business goes up, 30%, and our, half of that goes right down to the bottom line. Can I now draft in this agreement that I get X? Well, wait, buyers sort of balk at that. So that conversation does come up almost in whenever I'm talking about a MAC clause. But yeah, I'm carving it out and trying to limit it to something specific, numerical parameters, as much as possible. Depends on the business. If you're dealing with a business that has really low customer concentration, the loss of a couple major customers may completely change the deal. Certain kind of carve outs, if there could be, political changes. There's things. I've been fortunate. A lot of that hasn't happened in my deals, but I'm really trying to limit it to things really out of the ordinary that are not otherwise mitigated. And it's
What about like general economic downturn or uh, COVID or like what about how do those play into it?
I think on COVID, I think you guys would agree, everyone missed the boat on COVID.
Mhm.
In the corporate, that came up, and people were looking at agreements and thinking, wait, this really isn't force majeure. What is this pandemic? And now we'll see that in agreements. And I think legal bar sort of learned after COVID, okay, and we sort of learned based on the past. Those are pretty tough to negotiate in because they're foreseeable, and things happen. If you have a building catastrophe, there's insurance, and maybe that doesn't change a deal. If there's, an earthquake or something like that, you know, those are foreseeable. Or if there's a hurricane, there's always the sell side. I'm trying to really avoid that as as a MAC provision. But when I'm on the buy side, my thinking is sort of flipped. But I think in the more sophisticated deals, I have not been able, when I'm representing buyers, to get those outs. You're competing against buyers, other buyers, and from the buy side, if you push a sell side too much on these issues, they may walk away. And
So
I, the
from the buy side then, when an on-the-ball sellers council gives you a list of exceptions with things that don't constitute a material adverse change, which includes general economic downturn that doesn't disproportionately affect the seller business or pandemic or things like that, you have a tough time getting that out of the agreement because
I do. I think that the private equity world has sort of been leading the charge in M&A provisions and guiding our legal practice over the last 20 years, and that's where they're at. That's market. And there's always guidelines, every year, a couple different organizations that we all subscribe to that kind of publish what's market and what's not. And over pushing from the buy side MAC provisions could lead a seller to walk away. So it's why a lot of negotiation.
Yeah, I think generally, if it's something that's going to affect the market as a whole, then the seller will push to make sure that's excluded. But if it's something specific to that seller's business, then that's when I think the buyer will have more chances of getting sort of that not that to count, I should say, versus something such as just general changes in the market. And then, Michael, what you were saying on the sell side, when it comes to how the business may do better, I think sellers, what I've found to be helpful for sellers, especially if they have a business that seems to be sort of on the upward trend, is paying special attention to the exclusivity that they may give a buyer, because that gives them the ability in the short term to sort of take a look and see how the business is doing. And if it's doing very well and they have other potential buyers sort of at the ready, if you will, a lot of times buyers will come back and say, oh, we see it's going great. Well, maybe up the purchase price or give some other consideration that's helpful.
And some of it is sort of incorporated in valuation and purchase price terms. And I think we've all agreed, values in many businesses are pretty high. And I don't want to call it a fudge factor, but very often I see from the sell side, now that multiples are changing all the time. There's often, some upside, and I'm putting that in quotes, priced into a deal. So maybe that's why I don't see sellers push it as much. But sellers sort of forget about that, and they every seller we all have, wants their cake, the cherry on top, and the side of ice cream. So yes, I've got a high valuation for my business, but if I'm going to do better, then that higher valuation should even be higher. Who knows?
You mentioned multiples, and I'm going to skip around a little bit. Multiples and determining valuation, especially with financial buyers. Let's talk about indemnity for a while, and after we talk about indemnity, we'll talk about representations and warranties, which drive indemnifiable claims for the most part. Jackie, what are some of the key provisions and deal points in negotiating indemnification, including coming up with a definition of damages or what's an indemnifiable loss?
Yes, indemnification, I think we probably could have just 1 hour sort of on it. But generally, the first thing we're going to look at is, when it comes to indemnification, typically what the buyer and or seller, but mostly it's the buyer that gets most of the indemnification, is, what are they being indemnified for? So it's, breaches of the reps and warranties. If there's a loss incurred by that, breaches of the covenants, if there's a loss incurred by that. And then you can have sort of the on my watch, your watch type of things that happen on my watch, I'm responsible for if it's excluded, and things that happen on your watch, that's yours. So the first thing we'll talk about typically in negotiation is how long do those reps and warranties actually survive? Some of this may be influenced by whether or not the buyer will have a reps and warranties insurance policy. And so in those cases, many times the reps and warranties may either last longer, or if you're a very good, if you're a seller, very fortunate seller, I should say, the reps and warranties might actually terminate for you on closing. And then they will just look to the sort of reps and warranties insurance policy. You will also discuss sort of, as you mentioned, Robert, what are the losses that are actually indemnifiable and what can I claim? Right? So there are direct damages. So I suffered this directly. It came out of my pocket. I get to be indemnified for that. And then there are indirect damages. And so a lot of parties will negotiate whether or not those indirect damages, and sometimes what indirect damages can be claimed for indemnification. And so that's like punitive damages, consequential damages, loss of reputation, diminution in value. As you can imagine, a lot of these special indirect damages are things that have high dollar amounts. So on the seller side, you want to try to limit that. And on the buyer side, you usually want to either stay silent or try to make sure that those are able to be added in. And also, as Michael was talking about earlier, the companies do have insurance. And so sometimes, the seller may want to request for the buyer to have to seek insurance first, and then they are only liable for that. And then in addition to all of that, the seller will likely want to try to not have the buyer nickel and dime them, if you will. when it comes to indemnification costs. And so what they will seek is for what we call in the industry sort of a basket of sorts, where there's a certain amount of claims or losses they have to suffer and incur before they actually can then seek indemnification from the seller. Whether or not the seller has to indemnify them from $1 on that is negotiated. And then ultimately, the seller also wants to ensure that there's some sort of cap on what the buyer is able to get from them from indemnification. And so that may be the purchase price, that may be the actual cash consideration that they receive. If, as Michael said, there's sort of rollover equity, whether or not they get to go and reclaim that can be discussed, or it may be, a different amount depending on sort of what the leverage of the parties are.
And indemnity claims can dovetail with the type of purchase price structure. If I'm on the buy side and I'm aggressive, and to you listeners, I typically am aggressive on the buy side. If I have an earnout or a holdback note, I'm going to allow dollar for dollar offset on day one before I start asking for money. Uh, um, Also on the buy side, representing my financial buyers, I get into, and many times it's almost not worth the legal spend, but just it's important to the client. For a financial buyer, I'm arguing we're valuing your business based on a multiple of EBITDA. So limiting a damages provision as to calculating damages related to multiple of earnings doesn't work for us. If all of a sudden $1 million of revenue or EBITDA disappears because you lost a contract, my damages aren't a million. My damages are a multiple of that, because those are real damages. So, I've had some extended, I don't want to say fights, but good faith negotiations on damages definitions. You also mentioned caps, and I'll play devil's advocate for Michael and let Michael chime in once, you know, I want him to, if you can, Michael, talk generally about the types of representations and warranties, and as to, convince our listeners why certain of these representations and warranties perhaps shouldn't be subject to a basket or shouldn't be subject to a cap. Are there different types, or are they all subject to, after 1 year of survivability, you're done. I don't care which rep we're breaching, and if there is any damage, you know, you're still subject to the cap for it anyway, if it even occurred during that 1 year period. What can you sort of break them up and talk about what's market for each of the types on survivability and basket and non-basket and cap and non-cap?
In the world of reps and warranties, we M&A lawyers really divided into reps and warranties into two groups. And one group is smaller than the second group. And the first group is what we call fundamental warranties, fundamental representations and warranties. These are really important things. I really own what I'm selling. Sometimes various taxes are paid, and other items are really fundamental warranties. They're so important that if there's a breach of these, even if we find out a year or 2 years later, they may not last forever, maybe a statute of limitations. The damages are going to be really big, and it's really going to change the perspective of the deal. If these are breached, and I'm a buyer, I would not have done this deal had I known that this was going to happen. So the survivability period is going to be long. The damages cap could be, as high as the purchase price, sometimes even more, but usually you settle at the purchase price, because if I'm a seller, I'll say, look, I'll give you your money back, worst case scenario, but I don't, and there's some negotiation, Robert, to your point, which was very well stated. Um, it's multiples here. So if there's, a breach of X, it's really not costing $1 million, it's costing 6 times. So there's some negotiation over what is a fundamental warranty, sometimes environmental issues, usually ownership issues, tax issues, and so forth. Different M&A lawyers have different perspectives. And then there's kind of the reps and warranties that are, you know, maybe easier to quantify, and not a big deal. I represented my equipment, for example, was in great operating condition. Well, it turns out later, um, that there's, I don't know, $50,000 worth of repairs that were sort of like hidden, and that was a breach. It doesn't really change the fundamental of the nature of the business. And I, as a buyer, figured it out pretty quick. And there's some type of holdback, so I could just make a claim. It comes up with me a lot, and probably you guys too, employment issues or employment claims. It turns out, and everybody does their financial statements a little bit different, but it turns out there's some employment obligation, I don't know, vacation pay, just as an example, that we've done the math afterwards, and well, that was sort of off by 50 or 100,000. Okay, doesn't necessarily fundamentally change the deal, just sort of an internal thing. Um, as a buyer, I have a shorter period of time to figure that out, and get indemnified and get reimbursed. So and I'm at 5,000 feet. There's big ticket items and there's smaller ticket items as you go through the reps and warranties. And as a buyer, I want the bigger ticket items to survive longer. I want more time to figure it out, and it may not appear for a while, and I want, more damages. Um, but on the smaller items, I might accept less.
I would argue from the buy side perspective, let's take environmental. I mean, capping a purchase price is no bueno, it's no good. I mean, I buy a business and they inadvertently, let's say negligently, not knowingly, didn't realize they had a super fund obligation under the factory. And now I've inherited on my $25 million deal a $60 million cleanup that, I can't be capped at the purchase price. I mean, good luck finding the shareholders' assets,
Right.
to get that. But to me, that's non-cap all the way. Um,
Right.
what do you guys see as market being for the cap on indemnity, general cap on indemnity these days? It's been shrinking and shrinking and shrinking over the years, uh, from what I've seen.
Yeah, I think most times, and some of this obviously, especially as to what, whether or not how long it survives will be, based on industry and the type of business. But most of the times I find it to be purchase price, um, unless there's some sort of fraud. Usually, if there's fraud involved, then, sometimes you will sort of the purchase price cap will not apply at all. Um, but if there are multiple sellers, and they have fairly good leverage or have had um, a good process where they maybe have many different buyers and they're able to get it, it can be limited to whatever that particular seller actually received. So they're not, obligated to pay more than they actually received.
Yeah, I would agree with Jackie. That's what I'm seeing. Rep and warranty insurance, which we won't go into, is changed the dynamic a little bit with indemnities and recovery. You're as from the sell side though now, you're saying to the buyer, I've opened my books, you've examined, it's not perfect. Operations go up and down. So I don't want to be nickeled and dimed. So there's some sort of basket. And I want to be kept. I want to know when I close this deal, I'm moving on. Take your time. I'll show you everything. Um, and again, the buyer, I mean, it's a game of ping pong, up and back. The buyer's like, especially with tax issues and state tax issues. where it's almost impossible for a buyer to know if are the returns correct, are they filed right. I mean, half the time, and the sellers don't even know if it's done, if they're going to get audited. So I have had a lot of tax issues, especially local and state issues, year, 2, 3, 4 years after the closing, because just both sides are taking a guess. And you look at the accountants for certainty in filing the returns, and and not to get off on a tangent on this, the accountants will always say, "Look, I'm filing this based on the information I have." So it's very fluid, and it gets complicated. But I'm seeing purchase price, but I'm seeing, and I agree with you, Robert, caps are shrinking. Um, could be X% of the purchase price for non-fundamental reps and warranties,
Right. Most
5%,
of what I
10%.
see now is at least from the buy side, I have to push very hard to get north of 20% of the purchase price. Granted that that there's going to be a whole host of things that are non-cap, taxes,
Right.
environmental, ERISA, you know, those types of things. But the ABA market surveys for private M&A have a majority of indemnity caps now like in the 20 to 30 range, with a goodly percentage south of 10%. And with this newfangled thing called the internet, the publicly available information out there is ripe for the taking, and it's tough to get a well-informed seller's counsel. You start at the purchase price, or you don't even have a cap in there if you're an aggressive buyer in your first document, but you're going to be met with resistance, and it's very hard to have someone who's armed with the appropriate information to really get them, north of 30%. That's been my experience in the smaller, M&A. In the public world, it doesn't matter. The deal closes, it's over. There's really not much, indemnity wise. So, um,
That's yeah, and I think in private equity they'll push the buyers usually have the power at least to push the seller to say no, it's purchase price in many instances. But one of the things as Michael was saying, like when it comes to taxes and those things where the buyer definitely doesn't know. The seller hopefully knows or may not, but in many cases some of the sellers in those instances would prefer to lead the litigation or whatever discussions, negotiations that when it comes to those potential claims. And so negotiating who leads the indemnification claim process is often something that's also negotiated and can be sort of divvied up depending on the circumstance.
Yeah, yeah, Jackie, that's a good point. I've had a lot of negotiation on who's going to lead and how indemnification process is going to work. And then I always have to laugh when the issue comes up. Um, it's sort of like a hot potato, and people are like, "Oh my God, okay, what do we do to figure this out now?" Not to pick on state tax issues, but um, both sides are, oh, I know I negotiated, the right to lead and controls litigation or this protest or whatever, but I don't want to anymore. I don't understand it. Or you get a lot of negotiation. But I was just going to say also, it boils down to leverage. If it's a really great purchase price and a seller is happy to get this deal and they really want to close, they tend to be flexible on other terms, because they want to get to the finish line. And if they feel like, hey, we have a clean company, we've disclosed everything, they may agree, Robert, to your point, with a higher cap. So, you know, it all depends.
all right, let's go back to a little bit of purchase price talk, because one of the things that I found as a increasing in the marketplace, principally as a result of COVID, and I think now perhaps might even be seeing some because of uncertainty in tariffs. I see more in the way of earnouts now because deals are much harder to price. So Let's go with Jackie. Jackie, you're representing a seller, and they've agreed in principle to an earnout. You're representing them, right? What are your concerns in drawing an earnout provision that best protects the sellers to make sure they get paid?
Yeah, depending on the type of transaction, and what I mean in that is whether or not the seller or the principals of the seller, right, will be able to continue in management going forward. So right now we'll assume they won't. Um, my concern from the sell side is this will no longer be our business. There will be different people operating it. So how do we ensure that the buyer's not going to do something to ensure you don't get that additional purchase price? And so a lot of times you want to negotiate provisions, which at a minimum will say that the buyer will not act, like intentionally act to not meet the milestone, not meet the EBITDA, etc. Sometimes you may want to try to negotiate, if you have good leverage, additional things, which say that that the buyer will do certain things that historically has allowed the company to operate properly. And then on the other side of things, you want to ensure if the buyer is going to change something or exit the business during that earnout period, that you still get the money. So a lot of times you may ask for acceleration provisions where if there's a change of control, that it's deemed that you've earned the earnout and the funds are due. So those are some of the things that I would look at from the seller side.
Just a couple comments on earnouts. Earnouts are almost a guarantee of more business down the road for us attorneys because there's and I'm curious, Robert and Jackie. I've done many deals with earnouts, representing sellers and buyers. Um, and there's always a dispute. There's always a dispute, even if it's drafted great, the accounting, well, they're accounting for this different and they're, turning the numbers, or it's either in the accounting, the auditing, the taking action, and so forth. It's almost human nature that down the road, I shouldn't say I've had a few smooth ones, but I have had many PE clients and many buyers, Robert, you're right. We're seeing more earnouts. Just simply say, I'm not doing an earnout. I might take a little bit cash now, but I do not want to get into those debates down the road, whether, and it's almost like an invitation for a dispute. I'm just the counterpoint where some people just, won't do earnouts.
No, I think that's right. And I've also had times where the sellers, they are sort of rolling over in management, whether it's, for a period of time or so, but they've been forced out. And so, thankfully, at least in one of those situations, we did have a provision due to bad experiences previously, that said if they were forced out or their duties were materially altered and reduced, that meant the earnout was deemed. So those are things also that the sellers may want to look at. But I have had a lot of clients this year really pushing back on earnouts when they're included. Thankfully, it's been a fairly good market for many of them with multiple potential buyers.
When I'm on the sell side and we're in the letter of intent stage, the first thing I talk to the sellers about is there's a lot of risk with the earnout. Are you sure you're going to possibly shoot the moon and make a lot of money? And do you really, really trust the operation of the company and trust just on the good faith concept of this buyer? Because if the answer to those questions is, goes the different way or there are any reservations, thinking about pricing it out and taking less and leaving the closing. If you are in earnout land, basic things. One, a reporting provision. You get reports in reasonable detail with backup. You have the right to contest, right? The costs of any contest, if it goes to arbitration, are borne by the loser if it's within a band. You want a good faith and fair dealing covenant from the buyer. because I've had helped our litigation group here when sellers have been disappointed by their buyer's performance because the buyer completely changed the business, threw a lot of expenses in there, killed EBITDA, only to depress the earnout and to kill the deal. We prevailed in that one. We hit the home run for the client. But uh, those types of things. Could I have budget approval, right? Certainly, as Jackie said, acceleration if they sell the business, or even if they sell a material part of the business. All those types of things. Uh, and the last caution I have for the seller in that scenario, which is the legal spend. You're going to go down the earnout road. I want to protect you. If I'm going to protect you, I'm going to tell you that I have sometimes been involved. You know, I'll say days, but that doesn't. 2 days doesn't mean 48 billable hours. But protracted negotiations on protection earnout language. So be sure, sleep on it, think about it before you commit to the earnout, and think about whether or not you're willing to live without much recourse in the event that this buyer turns out to be either bad at the business or untrustworthy.
Last comment on earnouts too, and I agree with everything Robert and Jackie said, is if a seller will take an earnout, my recommendation is make it easy to measure, a percentage of the gross. I have seen many convoluted formulas for earnouts, and I know, the accountant in me just knows, here's 4 holes I can drive a truck through from either side in this formula. Make it easy, make it easy to play. That that will help.
Mhm.
That's it.
Okay. I'll give you each an opportunity to throw in a closing remark on an important provision that we skipped over because we went down the earnout rabbit hole. I'll start with Jackie. Pick one thing that's, and with a tidbit for it.
Yeah, I think I'll talk about non-competes, which are often, heavily negotiated in transactions. They
Jackie,
can,
before you start, that was going to be my topic, but go ahead. Maybe we'll talk on the same
So
topic.
we'll have a 2-minute convo on non-compete starting with
Fine,
Jack.
I'm sorry.
yeah, most of the times you're going to want it in the acquisition context, so the sellers will sign it, and many buyers are going to look for also many of the key employees to sort of have those non-competes or non-solicits. My advice to any company and seller sort of and buyer looking at these things is to know your jurisdiction and what's required. Many jurisdictions have limited the ability for you to ask for them in the employment context, definitely, but even some in the now in the acquisition context, depending on how broad they are, and even in the well-defined Delaware chancery laws, the scope of what you can ask for has been somewhat narrowed. So definitely think about what you're getting and what's actually needed.
Michael, so I'll put it to
Yeah.
you, which is, hey,
Yeah.
what's the difference? Why do I need a non-compete in my purchase agreement? I'm signing an employment agreement and that has a non-compete. Where from the buyer's point of view? Where
Yeah,
from the buyer
yeah.
here?
Non-competes are really important from a buyer standpoint. And a non-compete, and I'm sure we'll get into this because we don't have a lot of time in a later session. A non-compete in an employment context is different from a non-compete in a sale of a business context. And that's sort of a little preview for future conversations. Um, when I'm a buyer and I am buying a business from a shareholder, um, what am I really buying? I am buying that shareholders, that owners, relationships, know-how. And if that shareholder is going to, 3 days after a closing, start the same business and attract all his customers, and believe me, I have had many relatively sophisticated buyers and sellers not really get this point then what is a buyer really buying? If a seller can start, the same business a block away and take all the customers, well, that certainly um, really changes the value. And then I've had some sellers saying, well, that guy's got to, that buyer's got to compete like I did when I was starting out. Yeah, but you're asking a high multiple for your business. So from a buyer standpoint, I am buying the institutional knowledge between the ears of this owner seller, and I don't want him competing with me. That's not what I'm paying for. He could go get a job doing, and we're negotiating doing something else. But if he's going to take away the benefit of my bargain, what am I paying for? And there's a lot more we can talk about with this issue down the road. Little
All right,
preview,
well,
sneak
that
preview.
wraps up our time for today, giving our listeners and viewers the benefit of their bargain. Thanks again to Jackie and Michael, and again to our co-producers, the National Law Review and Financial Poise. Please join me on October 7th for episode 3 of the 2025 M&A Boot Camp. That episode's going to be the M&A process. Hopefully you'll join us then. Till then, stay safe, go Ravens, go Bears, and let's not talk about my Giants.
Thank
Thank
you.
you, everyone.
Bye.